The Court International of Justice is the main organ judicial of the United States and is located in the area, responsible of resolving legal disputes among state parties. The court has a dual missions: the settlement of disputes of a legal national among the state at summarities on the latter the united of advisory opinions of legal matter submitted of the organs of agencies of the United Nations. The function basic is to resolve the disputes of litigation of the state or country in question, as well as to use opinions and provides advisory opinions of legal issues that are raised by the Assembly of the United Nations or by the Security Council of the ONU.
The International Court of Justice may analyze two types of cases: contentious cases, which are legal disputes between states submitted to the court by themselves, and advisory proceedings, which are requests for advisory opinions on legal questions referred to it by the United Nations organs and specialized agencies. Only states that are members of the United Nations and other states which have become parties to the statute of the court or which have accepted its jurisdiction under certain conditions may be parties to contentious cases. The court is competent to entertain a dispute only if the states involved has accepted its jurisdiction in one or more of the following ways. 1. By entering into a special agreement to submit the dispute of the court. 2. By virtue of a jurisdictional clause. Or 3. Through the reciprocal effect of declarations made by them under the statute, whereby each has accepted the jurisdiction of the court as compulsory in the event of a dispute with another state having made a similar declaration. States have no permanent representatives accredited to the court. They normally communicate with the registrar through their Minister of Foreign Affairs or their ambassador accredited to the Netherlands. When they are parties to a case before the court, they are represented by an agent. An agent plays the same role and has the same rights and obligations as a solicitor in a national court. However, since international relations are at stake, the agent is also, as it were, the head of a special diplomatic mission with power to commit a sovereign state. He or she receives communications from the registrar concerning the case and forwards all correspondence and pleadings duly signed or certified to him. Proceedings may be instituted in one of two ways. 1. Through the notification of a special agreement. This document, which is bilateral in character, can be lodged with the court by either or both of the state's parties to the proceedings. A special agreement must indicate the subject of the dispute and the parties. By means of an application. The application, which is unilateral in character, is submitted by an applicant state against another respondent state. It is intended for communication to the latter state, and the rules of court contain stricter requirements regarding its content. After the oral proceedings, the court deliberates in camera and then delivers its judgment at a public sitting. The judgment is final, binding on the parties to a case and without appeal. Any judge that wishes to do so may append an opinion to the judgment. By signing the Charter, a member state of the United Nations undertakes to comply with the decisions of the court in any case to which it is a party. Since, furthermore, a case can only be submitted to the court and decided by if the parties, having one way or another, consented to its jurisdiction over the case. Advisory proceedings. Advisory proceedings before the court are only open to 5 organs of the United Nations and 16 specialized agencies of the United Nations family or affiliated organizations. The United States General Assembly and Security Council may request advisory opinions on any legal question. Other United Nations organs and specialized agencies which have been authorized to seek advisory opinions can only do so with respect to legal questions arising within the scope of their activities. When it receives a request for an advisory opinion, the court must assemble all the facts, and is thus empowered to hold written and oral proceedings, similar to those in contentious cases. A few days after the request has been filed, the court draws up a list of the states and international organizations that are likely to be able to furnish information on the question before the court. Such states are not in the same position as parties to contentious proceedings. Their representatives before the court are not known as agents, and their participation in the advisory proceedings does not render the court's opinion binding upon them. Usually, the states listed are the member states or the organization requesting the opinion. Any state not consulted by the court may ask to be. The written proceedings are shorter than in contentious proceedings between states, and the rules governing them are relatively flexible. Participants may file written statements, which sometimes form the object of written comments by other participants. The written statements and comments are regarded as confidential, but are generally made available to the public at the beginning of the oral proceedings. States are then usually invited to make oral statements at public sittings.
The International Court of Justice has jurisdiction to resolve disputes between the member states of the United Nations, other state parties according to the statutes of the court or that have accepted their jurisdiction under certain conditions. Now we are going to point out some Latin American cases submitted to the jurisdiction of this court. How was it? Nicaragua and Colombia, for maritime limits and sovereignty over Iceland, and case of the San Andres Archipelago. Peru and Chile, by maritime limits and border demilitation. Costa Rica and Nicaragua, for violation of sovereignty and serious environmental damage to Nicaraguan territory. Ecuador and Colombia, for fumigation with glyphosate in localities near and across the border with Ecuador. Argentina and Uruguay, for installation of a cellulose plant near the border with Argentina due to environmental contamination.